Welcome back to Maryland Law Explained podcast with Todd Mohink, the show that breaks down Maryland family law for the families of Glen Burnie and across Anne Arundel County. I'm Brooke. Today we are tackling the question almost every Glen Burnie family filing for divorce asks first. How long is this actually going to take? We are walking the road from the day the paperwork hits the courthouse in Annapolis to the day the judge signs the final decree. And I have exactly the right person for it. Todd Mohink has spent 30 years in Maryland courtrooms. He argued Braun versus Headley, and he handles the cases right here in Glen Burnie every week. Todd, welcome back.
Thank you. Hi.
Hello. Happy to be here with you again. A lot of Glen Burnie couples picture divorce as one quick court date and then they're shocked when months go by. For a couple in Glen Burnie, how long does a Maryland divorce really take from filing to final decree?
If they have an uncontested divorce, which means that they have an MSA or marital separation agreement, which means that they've come up with answers for all of the questions, pretty much from divorce and custody all the way down to counsel fees, then they can submit what's called an uncontested divorce request, meaning that because the agreement resolves everything, that they're done. I would say if they do it that way, then they're looking at 2 to 4 months, depending on how quickly the paperwork passes. And that requires usually a Zoom hearing, which is only about 10 minutes long, to get the testimony necessary to get the divorce. And then the agreement just becomes part of the judicial divorce. And then the other way is if it's litigated, meaning that if a complaint for divorce or custody is filed, in those cases, if it is litigated, meaning that the parties do not agree on any of the big issues, divorce, custody, property, assets, retirement, then that means that they'll probably have to go to trial. If they're looking at trial, I would say a minimum of a year to a year and 3 or 4 months.
Yeah, so this is not something that happens quickly. Some couples have already worked everything out and just want the quickest legal exit. What is a mutual consent divorce, and is it the fastest way out for Glen Burnie couples who already agree?
It is a mutual consent divorce, means that both parties agree that they can be divorced, and that can be based on being apart for different periods of time, but 6 months is the requirement of the state at this point. And then if those agreements happen and the parties agree that they've been separated, then that will allow the parties to actually get a divorce. Maryland has changed its grounds from divorce from a number of different ones to one called irreconcilable differences, which means that now, even if you live, and this is super important, even if you live in the same home, you can still seek a divorce from your spouse.
Okay. Now, something else that's unique to this area is people assume that there is a courthouse in Glen Burnie itself, and that trips them up from day one. Where does someone living in Glen Burnie, Maryland, actually file for divorce, and what should they expect at the Annapolis courthouse?
They file at the Circuit Court for Anne Arundel County, which is on 8 Church Circle in Annapolis, 21041. And basically, that is the circuit court for the county of Anne Arundel. In Anne Arundel County Circuit Court is the only place where divorce and custody decisions can occur that are on a more permanent basis, meaning of ones that are other than from a protective order or that kind of thing. And that is in, like I said, 8 Church Circle, downtown Annapolis. And the short answer is that unless they have a completely uncontested divorce, meaning that the only thing they literally have to do is say that they don't live together anymore and that they were married, then I do not recommend anybody, either contested or uncontested, doing this without a lawyer if it's affordable to them. And obviously, if it's not affordable to them, there are some agencies out there that will help litigants that don't have lawyers.
Absolutely. So it really sounds based on what you're saying, the fast path exists only if you agree on everything. But a lot of Glen Burnie listeners are wondering about the rules that used to apply, the separation requirement, and what happens in those first stressful few months. So let's get into that. This is one of those rules everyone thinks they know from a friend's divorce 10 years ago. Do Glen Burnie spouses still have to live in separate homes before a Maryland court will grant the divorce? Now, I know you talked about this a little bit, but I'd love for you to get into that a little bit deeper for us.
Yes, the answer is that since the last set of major litigation on the issues of divorce and custody, the legislature has allowed the change to occur where parties can seek divorce while they live together. I am not saying in any way that makes it easier. And in some areas, I think it makes it much more difficult when the parties are still living together, but they can legally file while living together at this time.
And now, once the case is filed, life doesn't pause. There are kids to feed, and of course, there are bills due next week. What is Pendente Lite relief, and why does it matter so much for a Glen Burnie parent in the first few months of a case?
Pendente relief is Latin. That means prior to the litigation. If I was explaining it to someone who is not a lawyer, I would say it is a temporary solution to the problem. In the stage of divorce and custody, there are two stages. The first stage is from the time it's filed until the time you reach what's called the merits in the case. And that's Pendente Lite relief, which means you could be asking for things like temporary child support, temporary custody, temporary alimony, but it is all with the understanding that it does not have an effect on the final or what's called the merit stage, which is the stage you reach when you're up for your final divorce.
Okay. Now, Glen Burnie sits right next to Fort Meade. So a lot of these families have a service member in the mix. With Fort Meade right up the road, how does a military family's divorce timeline differ for Glen Burnie service members?
First of all, I'm pretty experienced in this area because I would say a good 40% of my practice of people who are either at Fort Meade or NSA or those kind of places who have either been in the military actively or were in the military and now do consulting work, which is big for post-military folks. But the answer to the question is the rules pretty much remain the same, except for one important thing, which is in the event that a party who is served. So if the plaintiff, for example, files against someone in the military, that person in the military has the right to be protected in the rare event that they've been deployed or that they're in a place where their commanding officer can write a letter to the court and say, my client's not able to be here because they're in a war zone or they're deployed or whatever. So that is really important. There's a committee called the SCRA, which is for the Civil Service Members Relief Act. And I am on that panel in Anne Arundel County as an attorney who voluntarily gets on this list so that if a party is allegedly served and if that party's in the military, then under this SCRA, which is a federal act, they are appointed an attorney by the court, which the non-military party must pay for. It's only $500. And then it becomes my job, once I'm appointed by the court, to get in touch with the person, the defendant, and find out, number one, do they live around here and could they get to court if necessary? And number two, which is actually more important, is are they deployed? And if they are they deployed in a place that would stop them from being able to receive a divorce? So those are really important issues. And then just to wrap it up, there is also an issue that a lot of folks in the military don't understand, that if you are at Fort Meade or if you're at NSA, then Maryland law controls, not federal law. So that's a difficult issue for a lot of people who are active in the military and think they have an understanding of how divorce and custody law works, because it is not the federal government that just gets to decide that or even decide retirement. It is Maryland state law that figures that out. So that is really important.
Yeah, for sure. Something else that I was just thinking on, I don't know a ton about the military, but I know that there are like military pensions and just different military benefits. Do those kind of ever extend the timeline in which these divorces get settled? So I'm sure that's a lot to figure out, especially when there's kids and everything involved.
Yeah, there's a formula that the courts use for things like retirement. It's called the Bangs formula, Bangs. And to make a long story short, it basically compares the time that you have been working or owning a residence until the time that you're getting ready for divorce. And that's how the court figures out who gets what when it comes to that. So if a party has what's called a premarital interest, which means it's something that they acquired before the marriage and have not put marital funds into, or if a party had an inheritance or a gift, that those matters would be separated out of the pile when it came time to figuring out assets and who gets what.
Okay. Now, for a Glen Burnie household, maybe one spouse is working out at BWI and the kids in school. This is a day to day fear. Who pays for what? Where do the kids sleep while you wait? How are the bills, the kids, and the house in Glen Burnie, Maryland handled while the divorce is still working through the court?
Those are great questions. And the answer to the questions is part of it is who files first. And I'm not
Okay.
saying that means that's the right thing to do, but the case doesn't get moving until someone files and then someone gets served. And that's how the litigation process begins. But the answer to your question is that there's two ways that this thing gets decided. Either the parties decide that their children are more important to each other than hurting the other person, or they realize that maybe it would be better for the kids if instead of fighting so much, they simply came to an agreement and went their separate ways. If those things happen, then either of those things can lead to an uncontested custody case or an uncontested divorce, which, in my opinion, the most important thing is doing everything that you can to protect the children.
Absolutely, the kids are the most important. Those first few months are where a lot of cases either calm down or completely blow up. So let's talk about resolution, how families actually get to the finish line and the mistakes that drag it out. When people hear contested divorce, they picture a courtroom brawl, but most cases never get there. How does mediation work for a Glen Burnie, Maryland divorce, and can it genuinely shorten a contested case?
Yes, it can work, and yes, it can get a case to become contested. In Anne Arundel County Circuit Court in Annapolis, the policy of the court is that for every case where domestic violence is not an issue, and even in those cases now, because the majority of mediation is done by Zoom, so unless the court finds a really good reason, the mediation is going to be required by either the court ordered mediator or a mediator that the parties agree upon. That costs usually $200 per visit for each party, and it requires two mediation sessions. I think that mediation is excellent. I think that mediation very much depends on matching the parties and what they're going through with the mediator that you think has the right personality to get those matters addressed.
Okay, so like what sort of issues settle cleanly and lead to a marital settlement agreement?
Divorce is usually the easy one because by the time people come to see me or find me or whatever, they usually are in a place where they, for the most part, have been separated, which makes it much easier. But they, if they agree on the divorce, that makes it uncontested. If they agree upon custody, that's a big deal because there's two different types of custody in Maryland. There's physical custody, which is where the child or children actually reside in what time, how many days a week, that kind of thing. But then there's what I believe is equally important, which is what's called legal custody. And legal custody is decision making about what they call the kids' health, education, or welfare. Most of the time, that primarily deals with adult issues such as religion, such as medical care, those type of things where the parties really do care about those couple of things. Those seem to be the things where the largest standoffs occur.
Okay, I appreciate you sharing that. I was genuinely curious there. A lot of the delay people blame on the system is actually self inflicted. What are the biggest mistakes that drag out a divorce for Glen Burnie, Maryland couples?
I think it's a couple of things. I think it's fear, because I think a lot of couples believe that they can't afford attorneys. And because they can't afford attorneys, they try to chat GBT it, which I think does not really help a whole lot. There used to be a time when people would come in to meet me and I would sit with them at a conferencing table and say, tell me what you want for physical custody, tell me what you want for legal custody. And I would write down my notes and then we'd ask for that when we filed. Now people come in with a 20-page chat GBT chart that tells you tons and tons of information that has no relevance to what we're trying to accomplish here. So those are my experiences in that regard.
Okay, gotcha. Now, every firm will tell you to hire local, so let's get specific about what knowledge actually buys you. Why does having a lawyer who knows the Anne Arundel County bench change the outcome for a Glen Burnie divorce?
The biggest thing for me is I think that the judges find me credible. And when I say that, what I mean is I think when it comes to judges, if you're an attorney who appears before them regularly, and when I say regularly, one time a week at a minimum, if not several times a week, then you get to the place where they, they decide that you're either credible or you're not credible. And I think that the credibility of the attorney itself matters so much to the judges that I think someone like me who has credibility with the court in terms of being a respected member of the bench and a respected, or when I say a member of the bench, a respected member of the bar and a member who the judges give a fair shake to, that's the best thing I could ever ask for.
Absolutely. So that's the timeline start to finish for a Glen Burnie family. Todd, let's land it for someone listening who knows this is coming. Todd, if a Glen Burnie listener takes one thing from this episode, what should it be?
That attorneys are very helpful to you if you are going to get through a divorce situation. It is often better off to at least consult with an attorney before you make any moves. And the most important thing is the children come first. And no matter what you do or how you feel about your spouse or your baby's parent or whatever, please remember that the children are the most important thing, and that when things are tense and the temperature's up, they know.
If you or someone you know is facing a divorce in Glen Burnie or anywhere in Anne Arundel County, Todd Mohink and the team at the law offices of Todd K, Mohink, PA are here to help. Call them directly at 410-766-0113 or visit marylandlawhelp.com. That's marylandlawhelp.com.